Did you know that you can be held liable for any environmental contamination you never caused? An Ontario court ordered a property owner to pay $1.2 million even though they never were the ones that caused the pollution and contamination. Here is what every buyers and sellers of commercial and industrial lands need to know. So the background was a former dry cleaning business had contaminated a commercial property with hazardous chemicals that slowly leached and migrated onto the neighbor's property. So, they were doing dry cleaning and slowly and steadily all those chemicals were leaching into the neighbor's property. So years later, a new owner bought that contaminated property. Although they didn't create the pollution, they knew about the contamination and they did nothing to stop the spread. So the neighbor sued the new property owner and the court had to answer four very important questions in this case. First, can a buyer be held liable for contamination they did not cause? Number two, does the ownership create responsibility if the contamination continues? Third, can neighbor owner claim compensation for the lost property value? Four, what duties does the landowner have once they know the contamination exists? So the Ontario Superior Court ruled in favor of the neighbor. The court found that the owner was liable for nuisance and negligence because they knew contamination was continuing to migrate but failed to investigate or remediate it. The neighbor was awarded $1.2 million for the loss of property value plus about $90,000 for engineering and environmental cost. The Ontario Court of Appeal also later held the same decision, and the message was very simple. You don't have to be the polluter to be legally responsible. So here is the lessons for the purchasers and the buyers. If you are buying a commercial or industrial lands, always complete phase 1, if necessarily phase 2 environmental site assessments. Number 2, review all environmental reports before closing. Number 3, include environmental conditions, indemnities, price adjustments, and remediation clauses in your agreement of purchase and sale. Fourth, never assume I did not cause it, so I am safe. If you know contamination exists and you ignore, you could be still held liable. And lessons for the sellers: if you are selling a contaminated property, number 1, disclose known environmental issues honestly. Second, keep all environmental reports and remediation records. Third, consider addressing contamination before listing with the agent to reduce legal risk and liability and protect your property value. Hi, my name is Jimmy Singh. I'm broker owner for Fortune 2 Realty, and I've been helping my clients buy, sell real estate across Southwestern Ontario, Greater Toronto area in Canada. And you can reach me at 647-961-2639 if you have any questions. And on my channel, if you haven't subscribed yet, I share real estate cases that every buyer, seller, investor should know before they sign the deal. Follow me for more real estate tips, pointers, court decisions, and practical advice to help you make smart property decisions. Thanks for watching.